Hello and welcome back to the Data Privacy Lawyer. It's Funmi, the principal attorney, speaking on the mic today. So I want us to take a look at Maybelline and how it deals with cookies. So I'm not entirely sure if they have a cookie notice, but we can see in a moment. I want to see how they deal with cookies. Let's have a look. Okay, so they have their website privacy and cookie notice. They've joined them together. Okay, so we've been presented with the cookie banner. Let's take a look at settings. And they have plenty. So they've got functional cookies, targeting cookies, strictly necessary cookies, performance, and social media. Now, each of these are different. And the reason they've made the distinction is because there are often responsibilities attached to some of these, particularly targeting and social media. If it's strictly necessary cookies, just for your awareness, these are always on. They let the website actually function. Generally, you can't turn these off. I don't think I've ever seen them ever have the opportunity to be turned off. And then in terms of the cookie consent manager, we've got another OneTrust one. So if you've looked at any of the other cookie notice audits that I've conducted, you'll see that there is usually a third party that assists organizations like Maybelline in this case to manage how cookies are utilized on their site, whether it's third party or it's first party cookies. Now, terminology is very important. Obligations and responsibilities are very important. Now, hopefully we can see this in the cookie notice we're about to take a look at. But if you're offering cookies, you are processing personal data. The terminology processing is very broad in the data protection space, and it basically aligns with any operation or set of operations you're conducting on personal data. And I also want to give definition for background about what personal data constitutes. Anything that identifies an individual is considered personal data. So when you look at the face of what cookies are, they might not look like they constitute personal data, but they are under the eyes of the law. So that's what we take a look at as privacy lawyers. Let's take a look at social media cookies. I also want us to take a look at this button. These cookies are set by a range of social media services that we have added to the site to enable you to share your content with your friends and networks. They're capable of tracking your browser across sites. So you might be wondering as a consumer, why is it that my Amazon site can tell that I want this Maybelline lipstick? It's because you visited the site and you opted in to the social media cookies, which I'm not going to do and I never do on this site, on this YouTube channel. But ultimately, you as a consumer need to know that this is happening with your information. The reason why you're obtaining those ads about Maybelline products on a different site is because you've either opted into the social media cookies or you've opted in on a different website where you clicked on a Maybelline link. There's a lot of different technologies now. There's a lot more sophistication in how they operate. And the reason I've clicked on social media cookies specifically is if you're an organization and you're getting into relationships or contracts with these social media services, on the back end, what the consumers don't see is you need to be very careful about what your contractual obligations are, what their contractual obligations are as well. Because if you don't put restrictions in place, some of these social media services can further use that information for a secondary use, and that might not be what's in line with your organization's privacy policies and practices. So be very careful, one, on the consumer front, and then two, on the organizational front of particularly the social media cookies, because these are heavily regulated by the data protection laws. And then also targeting as well. Targeting cookies. I love that Maybelline has made a distinction between social media and targeting because there are advertising partners now that are not necessarily social media services that offer a level of sophistication in technology about how you're targeted, okay? Which is a bit different from the social media cookies. And each one constitutes personal data. They are collecting each identifier. It could be in a separate means. It depends what they agree to contractually, but what Privacy Counsel can do for you is they can take a look at the contracts on the back end. They can also take a look at what you've put out in your preference center and work with OneTrust to make sure that it reflects what your business does, because this is separate. What Maybelline has put in their privacy and cookie notice is generally not part of the obligations and responsibilities that OneTrust has when they provide this preference center on your site. They're just in relationship with you. They don't draft this. This is what Privacy Counsel will draft. So Privacy Counsel needs to take a look at one, this banner. By clicking accept all cookies, you agree to the storing of your cookies. Privacy Counsel will work with OneTrust to make sure that your preference center reflects what you've put on the notice and also what you're collecting in terms of cookies. Not every organization is going to collect targeting cookies. Not every organization is going to collect social media cookies. So you need to take a look at that as a business. So confirm my choices. I'm just going to take a look at all of them to make sure I'm opted out. Okay, good. I am. So this is also a cookie notice. We're only going to look at cookies today. We've done lots about privacy. If you're looking at any privacy notice related audits I've done, take a look at the YouTube channel and you can see that for yourself. So the cookie notice here, it's actually spread throughout the privacy notice. So I like doing these audits because I like businesses to see what it is that they can do. Now, to me, reading through this whole document, and we'll scroll to the bottom and you'll see how long it is. We live in a very fast-paced society and consumers generally are not going to read the whole thing. Some consumers might, but most will not. And you as a business need to know that. One of the reasons why organizations generally split these into two is to make for easy reading for consumers. Now, depending on your geography, there are certain legislations that say that you should make it easy for your consumers to read the public-facing privacy documentation that you place on the site, but there's no real way that you as an organization have to provide this notice outside of what your geography requires you to do. That's what I'll say. One of the things that Privacy Counsel can help you determine is they can help you determine what geographies you offer your products and services. I know Maybelline is operating globally, so the obligations they'll have for their privacy and cookie notice is going to be different for an organization that only provides its services in the United States. So it really all depends. And one of the reasons I like looking at the global privacy notices and cookie notices is because their obligations are going to be different than an organization in just one geography. I will say that given the nature of how businesses are operating in 2025, most companies are global because most want their goods and services to be sold everywhere. Think about Home Depot. What are their offerings? Their offerings are like things for the house. Why would they restrict themselves to only selling to US consumers when they can sell their goods to European Union residents as well? The reason you have a business generally is to make money. You're not a non-profit. So giving yourself the opportunity to provide your goods and services outside the United States is advantageous from a financial perspective. But one of the things that you need to take into consideration then is, what are my obligations outside the US if I'm going to offer my goods and services there? So I've highlighted this for cookies because that's what we're talking about for this video. The first opportunity that we have to look at cookies in this notice is they give a definition of what cookies are and how they operate. They're data files placed on a device when it is used to visit the site to facilitate site navigation and to personalize your cookies, including tailoring advertisements, which we saw in the banner and which we saw in the preference center. If you would prefer not to accept cookies, you can change your browser settings to notify you when you receive a cookie, which lets you choose whether or not to accept it, or set your browser to automatically not accept any cookies. However, please be aware that some features and services on our site may not work properly, which is accurate. I want to take a look at their definition and if they provide a distinction between first-party cookies and third-party cookies, because that's really important and a good distinction for consumers because they might not know how those work. So in addition, Maybelline may use third-party network advertisers to serve advertisements and third-party analytic vendors to evaluate and provide us with information about the use of the site and viewing our content. We do not share personal information with these third parties, but ad network providers, the advertisers, the sponsors, and/or analytics service providers may set and access their own cookies, pixel tags, and similar technologies on your device, and they may otherwise collect or have access to information about you, including usage information. Now, this is very intriguing, this sentence. I'm not disputing that this can occur, but there are a lot of sophisticated ways to work with network advertisers that businesses should be aware of. This is why it's very important for organizations to look very carefully about the contracts they sign with these network advertisers and third-party analytic vendors, okay? What Maybelline is saying here is that they don't share any of your personal information with the third parties, okay? Now, I would be interested in how they facilitate this activity with a third-party network advertising to serve the advertisements without sharing personal information. But you as a business, you have an obligation if you get into business with any of these advertisers, if you're telling your consumers you don't share personal information with the third parties, but the contract says you do, that's something that a regulator is going to scrutinize. And it could put you in jeopardy of being non-compliant because what you're telling your consumers is you don't share personal information, but your contract says you do. So what Privacy Counsel generally does, a lot of people might be saying, why do I need a privacy lawyer to help me with a privacy policy? You know, I think on this channel, in a couple videos, I'm going to go through the boilerplate templates that you can get for a privacy policy for your website. A lot of organizations might not want to pay. You might be a small business. You might be wondering, why do I need a privacy lawyer when there are companies that offer me a privacy template that I can just download and fill in a couple details and it's done? It's not that simple. And I think this sentence is a very good example of why it's not that simple. If you're buying a template, a cookie notice, or a privacy notice, and it comes with pre-filled in provisions, you don't know for a fact that that's how your business truly operates unless you're scrutinizing it. Okay, I've highlighted this sentence because I think it's very interesting that Maybelline is able to go into business with third-party network advertisers to serve advertisements without sharing personal information with the third parties. It is possible that this is the case, but what the third parties generally want to do is they want data too. Data is the lifeblood of most organizations. If you're working with these third parties, sometimes there will be contractual provisions that say we can use the data in an alternate manner, and sometimes it is necessary to share personal information with them. The third parties, if you're using their contractual template, they might not have the level of sophistication to understand what constitutes personal information, which is why you need a privacy lawyer to help you determine what constitutes personal information, because as long as it identifies an individual, it is personal information under the data protection laws. And if there's a provision in the contract lists an identifier that you might not think is personal information and the third party doesn't think is personal information, but it is personal information under the eyes of the law, you put yourself in jeopardy of having poor privacy practices. So I like to see what other organizations are doing when it comes to their privacy posture, and I think I will be doing a video about these privacy policy templates, privacy notice templates that you can get and download online, because you want to be able to make sure that you're not in jeopardy of any type of enforcement action as a business. So I hope you enjoyed this cookie notice audit. I love looking at what's happening on a global spectrum with industries that I generally will work with. If you are looking for privacy counsel, take a look at my description below and I'll see you in another cookie notice audit.